Authorities present in the event, ladies and gentlemen, good morning. Welcome to the first budget week of TCU. This is the last day of our program, promoted by the Secretariat of Government Macroevaluation and the General Secretariat of External Control. The first budget week of TCU has the goal of fostering dialogue among specialists to update, improve, and foster the production of knowledge regarding planning and budget in the scope of public federal administration. For a better functioning of the event, you should have your microphones off or in mute, and your camera should be on for the participants that will be in the panel. Each panel will do their exposition in 15 minutes, including the use of PowerPoint presentations. Each panelist will have 10 minutes for the debate to comment the questions of the digital survey and their final remarks. This event is being transmitted by the official channel of TCU on YouTube, and the audience can ask questions through the chat, and they will be answered during the debate. The program today starts with panel 5, in which we will debate the dimension of consequentialism on budget and tax decisions. Article 20 of the Law of Introduction to the Norms of Brazilian Law. To conduct the panel and moderate the debate, we will invite Francisco Sérgio Maia Alves, Assistant of the Minister, Assessor of Justice Benjamin Zimmermann of TCU. Good morning, ladies and gentlemen. It's a great honor to be a moderator of this panel. I'd like to thank the presence of Dr. Edilson Vitorelli, Ana Paula Bittencourt, Dr. Cavalera de Oliveira, Dr. Júlio Macena de Oliveira, and Dr. Samantha Durbowski. I'm sure that your participation here will enhance very much the studies that are being developed in this budget week. And we will certainly learn a lot with the contributions that you have for this debate. Just to give you a brief introduction, the central topic of this panel is consequentialism. Consequentialism is a doctrine that started from the moral and ethical philosophy, which understood that the value of any act should be given especially by the consequences. This doctrine was brought into the law studies, especially in the United States. It is a very extensive doctrine regarding this topic, and basically we can highlight the works of Richard Posman, Neil McCartney, and the legal consequentialism is to value in the scope of a decision the consequences of different alternatives. In Brazil, consequentialism was virtually evoked in few decisions, especially from the Supreme Court, and it was positivized in 2018 with the law 3605, which will be the base of the debates that we will have today. I'm going to read Article 20 to you. It reads that in the administrative controlling spheres, it will not consider abstract legal values without considering the practical decisions, practical consequences of the decision. It will demonstrate the need and adequacy of the imposed measure or the invalidation of the contract adjustment process or administrative norm in face of the possible alternatives. The consequentialism brought by Lindy is regarding not only the legal sphere, but also the controlling sphere and the administrative sphere itself. It is a duty that it is for any law operator, anyone who could concretize an imposed norm. It is in the scope of the Brazilian Society of Law, and it was criticized by many law operators because the debate would have happened in a very hermetic way without having the opportunity for the participation of other stakeholders that are responsible to apply the law. In the fiscal and budget scope, the consequentialist arguments are used in the tributary matrix. They are used with the intention to modulate the effects of decisions that can cause a large fiscal impact. In the Federal Court of Accounts, this type of argument was used recently in the judgment of the declaration in the report of Bruno Dantas, the Justice Bruno Dantas. It was the nature of the transferring of the financial resources of the federal government to the subnational entities in the measure 318 in Article 5 of Complementary Law 173/2020. So it's basically resources, financial resources that were transferred to the states to combat COVID-19, and the discussion on counting it as the net income. So these topics, they're going to be used as an anchor for the debate. And before handing the floor, I'd like to ask the organizers to open the Meet Meters platform so that the participants can answer the survey. I'd like to thank the students of the university from the states of Minas Gerais, Rio de Janeiro, and if you are with us on YouTube, we would like to congratulate you as well, and I'd like to ask you to participate in the survey, since these results will be used on the debates and on the studies that the Court of Accounts will do after this event. With no further ado, I'm going to hand the floor to the Republic Prosecutor and Professor of the University of Mackenzie, Edilson Vitorelli. Thank you very much to you all. It's a pleasure to be here with my dear friends, Ana Paula, Samantha. Thank you. I'd like to thank TCU to invite me to participate in this event. I'd like to give a special salute to the academia students, especially the ones from my home, UFMG, the University of the State of Minas Gerais. So it is my home. It's where I started my college studies. I presented a short presentation. It is really brief. I don't want to speak over the time that is allocated to me because I don't want to extend the event. It's regarding the consequentialist control of the state, of the federal state. Well, basically, the idea here is to try to demonstrate the elements that integrate Article 20 of the law. The problem maybe is that this article was approved from an academic bias that rules on the decrease of the control from the premise that there is an excessive control of the administrative activity in Brazil. I have difficulties to dialogue with this thesis because every time I address this topic, it seems that I don't live in the same country as the people who say that there is an excessive control in Brazil. So to me, it's problematic when we see all the corruption indices and the deviations of funds. They are so explosive. And somebody says that there is too much control in Brazil. But it's not only that. One thing is what people would like this norm to say. And another thing, which is very different, is what it effectively says. This norm effectively says that, in the first place, is that the administrator cannot decide based on abstract legal values without considering the practical consequences of the decision. So, first of all, this norm is a norm of restriction of the administrative discretionality, which is based in the abstract value, that is the supremacy of the public interest. If the supremacy of the public interest is an abstract value, the administrator cannot use this supremacy to decide without considering the practical consequences of his or her decision. So Article 20 is, in fact, a way of qualification of the control of the controlled decision. It is a way of reinforcing the control and qualifying the control. So it's not a way to soften it. So I understand that the one who wrote this imagined that maybe this could be used to soften the control, but it is not what is written. So we need to interpret the norm thinking of the main leges and not the main legislatores. So if the person wanted to soften the control, they should have written it in a different way. The way it is written here, what the text means, first of all, is that the administrative sphere cannot make a decision without considering the practical consequences of their decision. I'm going to show some cases to you, and I hope that you understand it, because today, what is done in terms of budget is to take administrative decisions with total disconnection or lack of knowledge of the practical consequences of the decisions. So I really hope that after this event, we will start a new era, an era of budget consequentialism and fiscal consequentialism. Not thinking I will do whatever I want because the consequences will be good, but not because the allocation is discretionary or in the thought of the public interest. But as a matter of fact, when you think of the public interest, you need to think of the practical consequences of the financial budget choices and decisions. Without this, the act of allocation will violate the Article 20 of the law. Given this premise, we understand that the first task that Article 20 attributes is to the manager, to the administrator, not the controller. So this person needs to take into account the practical consequences. This is the first premise. The second premise is to consider or take into account means that does not mean that you're going to consider intuitively afterwards and implicitly. It's the opposite. Consider means to consider empirically, ex ante, and expressly. So the consideration of the practical consequences of the decision is a consideration that must be done explicitly and not implicitly, empirically and not intuitive. So it means to be concrete, to be based in demonstrations, in studies. And third, based in explicit motivation of the act and not only intuition of what would be the consequences. It is true, as a matter of fact, that it is difficult to define what is an abstract value, as well as it is difficult to define what are the practical consequences of a decision. And as it was mentioned in the opening of the event, maybe the deficient writing of Article 20 is because of the lack of discussion before publishing this law. The writing is so bad that the decree of 2019 intends to regulate this article of the LIND considering that they're going to consider the norms of the act. We'll consider the degree of abstraction. So it is one of the most excellent norms of the Brazilian law. So the person who wrote this decree really deserves a prize because they create a norm that means absolutely nothing. Yes, it is hard, I know, and maybe we should have discussed it before approving the law. What would be these legal values that are supposedly abstract that would justify or not the action in the consequences? The second point, and I identify myself more in this one, has to do with what consequences we're going to control. Consequences, I mean practical consequences, are an absolutely vast universe of possibilities. I wrote a text, and I'm going to share the link with you, establishing this chapter here. I can identify in this text at least 7 universes of possible consequences to be analyzed, and at least 6 possible criteria for the analysis of these 7 possible universes of consequences. So you can evaluate, for example, in the administrative act, the consequences, the ones specifically coming from the practice, or you can evaluate the macro consequences. They are indirect, not directly connected to the practice of the act, but the ones that spread to other groups, other scenarios that are not the one directly focused by the act. You can also think of the time distribution of the consequences. This universe is important for the fiscal policies. There's no use to say that in the short term the consequences justify the practice of the act if in the long term the fiscal effects will be worse than the short-term benefits. So the time and distribution of the analysis of the consequences is very relevant. Besides this, the alternatives. What would be the possible alternatives? There's no use to just imagine the consequences, suppose consequences that could be better, without knowing if they are available or not. Also, the representativeness of the analyzed consequences from the point of view of the population. That is this what the population would really approve? And also the social distribution of the consequences. We are in a very unequal country in social terms, so any consequence that we want to analyze will be distributed in an unequal way among the different social groups. How can we ponder upon that? It seems that the consequences that are reflected in vulnerable populations are more serious than the ones that are on less vulnerable populations. So we need to think of that. We know that this topic was thought in terms of economicity, but what I mean is, when we talk about consequences, we are not necessarily talking about economic consequences. We could be talking about a series of other consequences. And the point is, once we evaluate all these universes, how can I measure these consequences? And my proposal is for us to adopt a moderate contract, maximizing aggregated, non-egalitarian, and against losses consequentialism. I call it moderate consequentialism, the one that not only consequence justifies any cause. So you cannot invest public money in bitcoins, for example, and say that the consequence was wonderful and justify this investment in bitcoins. so it is a moderate consequentialism. It is concrete because it depends on an empiric study of the consequentialist evidences, maximizing because it intends to obtain the best consequences, aggregate because it should consider all these universes as a whole and not only one of them, non-egalitarian because the social groups that are least privileged must be protected from the consequences, and it is against losses, which means that the consequences that demonstrate losses are worse than consequences that stop gains. Even if the loss and the gains that were not allowed we can consider that a consequentialism is against losses. So it must be considered by the manager. And once you practice the act, it is also has to be thought of on the control. My answer is if it's taken to control using the same conditions, yes. TCU has done this. There was research with the new devices of the limbed, and I would say that I disagree of some inferences that this research says, but the data collection of this research is good. They talk about the appellate decision on the plenary 1352 saying that the TCU should dispense the values when the detection of the problem, the management problem, happened a long time later, for example 10 years later. So what did we reflect upon? If the manager has to take the money from the present budget to allocate in a fund to satisfy a target that was not satisfied 10 years ago, we will be resurrecting a health plan that is already extended, and maybe we will oblige the manager to put money in a goal that doesn't make sense because the epidemiological situation of the community must have changed. For example, the COVID-19. If let's think that 10 years later, it will make no sense, this type of investment. Of course, with no clear loss to the finding of the responsible ones and the judgment of the accounts. Although giving back the money doesn't make sense, but also we have to think of punishing the ones that was wrong and was acknowledged to be wrong.
Sorry to interrupt you, but you only have around a minute, okay? No, I'm finishing up, no problem. So that's the idea. The another point that I have is the 315 resolution from the TCU that also established rules for dialectical consequentialism, which is very positive. I believe Articles 14 and 15 will tell us that the technical instructive unit should allow the people who are receiving the deliberations to comment on these proposals and presenting the consequences. So I think the TCU is correct. Those people who bring the consequences to appreciation by the court are the managers, the administrator themselves. However, I'd like to bring attention to this observation that was made by the court in this accountability, which is the embargoes that were represented by the Federal Union, as were mentioned in the beginning. The declaration embargoes that were presented by the Federal Union in this issue of COVID, and the court said that the tone that was used in these embargoes brings up an alert for the use that is merely rhetorical for consequential allegations, almost always lacking empirical or scientific evidence, which is extremely problematic when we're talking about economic policies. The Article 20th of Linvi is not a device that should be used in a consequentialist analysis that is merely rhetorical without using empirical or scientific studies. And in first place, by the public administrators in order to demonstrate that these consequences are indeed evident in the present universe. So that's basically it. These are the conclusions that I already presented. So I think that this brings a good horizon for a few controlled black holes, so to speak. These are the links for those of you who want to access the article. The article came out on the FGV website. For those of you who want to read the text itself that has to do with this seminar, you can get that there. This is my contact for those of you who might have any question. This is my email. I'd like to thank you all once again. I'd like to thank the court. And now I would like to give the floor back to Francisco. Thank you so much. It was so very interesting, the approach that you brought us. So, in my point of view, also, oftentimes it's forgotten. The 20th article, oftentimes we forget that this is mostly pointed at the public managers. So it's seen as a role of the control institutions, but actually it should start with the public administrators. So now I would like to open the floor to Dr. Ana Paula Bittencourt so that she can talk about the theme of the panel. So, Doctor, good morning, everyone. Good morning to the panelists, to our colleagues, to our students, all our colleagues who are with us. I cannot help but to thank everyone and to congratulate the court for the initiative. This is a very important theme in the routine of public administration, and on the name of Dr. Ricardo Soriano, I'd like to thank you for remembering us and for the opportunity for the prosecutor's office to be a part of the discussion. And it's an honor for me to be here to speak here and to bring the point of view of a legal consultant who spends all her day around getting the most consequence out of public policies, which definitely has to do with this fiscal and budget discussion. I'm going to try and share with you a presentation. It's a long presentation. I'm only going to put on the slides that I think are the most interesting to our discussion. And in one way or the other, I'm going to make this available to everyone. I don't know if the presentation is... can you all see it? Yes, we can see it. All right. I'm not going to take too long on this dogma, because Professor Dilson already has covered this, but I can't help but to highlight that a few of the passages of the legal framework that we're talking about consequentialism and its positivation. Here we have a few of the expressions which oftentimes I think that bring a big amount of the debate around this theme, the way that it was expressly incorporated into our legal system. So here you have a command that talks about that in the three spheres, saying that there won't be a decision based on abstract legal values without considering the practical consequences of this decision. And the decision, like any decision, must have a motivation, and you must have a balance between the adequation of the measure and possible alternatives based on depending on what you're doing. So here, my intent here in our conversation is it's very simple. I want to bring a complementary perspective relating to what Edilson has already presented. I think we have this Herculean exercise of bringing Article 20 that relates with consequentialism. We must do this. The administration must do this, and I think it's based on our Republican principle. I think that if the device is used in the proper way, I think it has a lot to add in terms of transparency and motivation quality. But without a doubt, one of the background behind this discussion is in legal safety. I took the liberty of bringing a quote from an article which I identified and which brings about some strong expressions when it says that the proposal of Article 20 of LINDB is to guarantee legal security through the delivery of more qualified decisions, since the rhetorical use of very vague principles has been used as a facilitating and legitimizing element of superficiality and voluntarism. So, public policies and public administration acts should be based on this, and also in the control and administrative areas. So, as a client of the jurisdiction, I'm bringing this point of view. So this comes from the perspective of both those people who are being administered and the administration. And we know that oftentimes we have this situation which we call the pen blackout, when people are afraid to do things, basically. So here we have this terminology in which we can see that there's a hard time in definition. What are abstract legal values? Did we use the best legislative technique? Was it not technical, or maybe they used the expression of legal expression because they have a very well-defined content? I brought these quotes to you just so that we are able to speak the same language, so to speak. What I have in mind when we're talking about abstract legal values, these are less densified normative principles, those that are announced in wide terms without a single unequivocal meaning. And I also had the liberty of quoting our mediator, Francisco. I found an excellent text by Francisco. Congratulations, a wonderful text. And it also talks about indeterminate concepts with which conception am I going to use this legal passage, which oftentimes makes us ask if this is technical or not. So I don't want to get just a specific legal juridical word, and which might be a specific terminology, but to try and make it so that these people make it less dense as a way for the decision makers to act. So why am I focusing on abstract legal values? Well, here I'm going to quote the decree once again. When we're talking about abstract legal values and consequentialism, why are we talking about this? When we're talking about consequentialism, in our legal framework, we can ask whether consequentialism and the margin of use of consequentialism, what is the margin of use of consequentialism when I'm not talking about the use of abstract legal values? So, decisions, administrative acts, that in the way that they are being based and in its structure, does it take into account consequentialism? Are they going to use consequentialism when they're not talking about abstract legal values? Well, I have the impression that maybe the executive I don't think they have this restriction of the use of consequentialism, but when they use this, so when there are abstract legal values, then you have the command. Let's try, with the pretension of ensuring and bringing prestige to another value with legal safety, let's try and make it so that these abstract legal values are directed by the consequentialist logic. Here I brought a quote from this decision 561 that was mentioned by the professor, that brought about the complexities and the risk which happens not only in financial fiscal matters of the use of the consequentialism, but the concern that we have with the use of consequentialism as a whole. But the fact is the following: despite the existence of this concern, and despite our questions in regard to the quality of the device that we have, and even about the way that this topic was conducted and made positive, does it actually deliver what it proposes it to deliver? So if my objective is to bring legal safety, is consequentialism the way towards that? You could maybe even question if this is the best mechanism when we're talking about delivering the value that we're trying to ensure with this device. So I have certain issues that I brought here, some questions. I don't think I don't have the ambition to answer them. Is it possible to use consequentialisms in case in which it is not necessary to use the resource of abstract legal values, despite all of the concerns in relation to using consequentialism with the current legislation? Is there an alternative in the hypothesis that the decision is based primordially in abstract legal values? So let's say in the case of the manager that needs to make a decision, and a public administrator has the effective obligation of doing this Herculean effort that the device really requires. It's when I say it's Herculean, it's because it's very tiring when we see the way that the discussion is made around the consequences. Well, is there a way for us to run away from this? Well, eventually, the way that the legislation works now, if we use this, because it's not very easy to understand this issue of abstract legal values and consequentialism. It seems to me that no. I think that eventually let's say there's people don't accept the way that the topic was introduced into our legal system. Maybe we really must open up the discussion in society as a whole in order to improve this device. But I really think that there is a certain problem in relation to the use of this method or of this supposition in decisions that in which we have to use abstract legal values. So bringing it a little bit closer to our decisions in relation to fiscal and budget issues. Here is the part that I think is interesting. Every time that we see examples about what these abstract legal values would be, some of them are easy. I have some legal decisions here so that we can, as examples, but I think we can do this throughout the debate. So the dignity of a human people, the right to health, these are principles or legal values that are often used recently. But when we look at fiscal and budget and financial issues, we have something that in a decision that I brought in as an example, it says, this the precepts of responsible public administration. When we look at the normative framework of fiscal and budget law, and we go into the Constitution, the proposal of the constituent legislators in relation to this is simpler than what came about in the infraconstitutional legislation with the fiscal responsibility law, making it clear that there is a need to have responsibility in fiscal management. When we look at the fiscal laws in the Constitution, we had an imprisonment in the logic of the short term of the fiscal exercise. You have punctually one or another device that creates a medium or long-term perspective or transparency to enable control and analysis of public policies, such as revenue renunciation, waivers, or fiscal benefits, tax waivers. And there are no long-term visions, and it was basically the Senate looking at the consolidated debt. And the big step that we had here, the first big step that we had in fiscal management, was notably the fiscal responsibility law, which brought about the responsibility for responsible fiscal management. when we read the device, it seems to me that when it came up in the legislation, it was very densified, in my opinion, relatively densified. Well, it says, what does planning and transparency suppose? And the NRF brought about a series of mechanisms and instruments of what should be conceived as fiscal management responsibility. There's titles, chapters, and topics about these instruments with rules. So they basically brings rules, limits, restrictions, in the hypothesis where you don't follow the limits. And this was a big evolution. Of course, now we have a constitutional text which gave a big step in this relation. The Constitutional Amendment 109 brought about very interesting innovation in relation to doing an alignment of fiscal rules in order to talk about the debt in a way that is not as connected to financial exercise and aligned with what had already been done in the fiscal responsibility law. Just with your permission, I'd just like to alert you that we only have 1 minute left for your time. Oh, okay. But what I think is interesting in relation to this and bringing a perspective of the managers, this assumption that basically was born with a relatively high density, in my opinion, throughout the years and throughout the experiences that were lived in by us, by Brazilians. Responsible fiscal management, in my opinion, basically created wings, and it became a teleological interpretation, and oftentimes it seems like it became more of a legal value, which sometimes reaches a certain level of abstraction. I mentioned a quote here. I'm not going to go into the method of whether this decision was correct or not, but basically I wanted to say that a directive of ideological interpretation that questions any acts of public policies on the argument that it should be interpreted based on the base assumptions of the fiscal responsibility law or of the new fiscal regime of Constitutional Amendment 95. And this is the drama of the public administrator that I wanted to share with you. It's like the public manager and administrator was sleeping and waking up in the middle of the night with the presence of an abstract legal value looking at him with a Mona Lisa smile, and that's when they have a heart problem and start palpitating. So we're talking about the dignity of the human person, responsible fiscal management. But here we have a variety of decisions. I think we can talk about them later. I'm going to mention one that was very important for the prosecutor's office, which was in relation to concentrated control environment when we got to a moment of inflection for the resolution of demands in the beginning of the pandemic about public spending, and we had a legal system that was absolutely not ready for a crisis of the dimension of the one we lived. And if you take a look at ADI 6357, the Justice Alexandre de Moraes, when he was analyzing the possibility of taking away a few of the financial rights laws, the text was basically based on principles or on values like life, dignity of human people, health, and the consequence when we see the decision is that there's no demand of the consequence, but certainly about this justification of what this would imply in terms of the maintenance of the rules, what would be the consequence of the maintenance of the rules inside the context of this unpredictable situation that we were living in. But, well, basically, I don't want to go into my colleagues' time. I'm going to make other decisions available that were based on this, and Above all, I'd like to highlight here what, in the administration perspective, we think of as something that's very important: the open debate with the Federal Court of Accounts. We think it's very important for us to think about this device not only by the administration but also by control institutions. We understand that the proposal of ensuring and preserving and valuing legal safety is great, even though the device as it demands a certain amount of improvement. Well, I'm going to open the floor. I'm going to interrupt my screen share, and we'll talk more throughout the morning. Thank you, Dr. Ana Paula. Thank you for your presentation. We can see that there's a certain relationship of a complementary nature, as the doctor said, with the passage of Dr. Gilson. And I thought this approach was very interesting in the issue of abstract values. It's really hard to, in law today, this issue of principles and values, and it's really hard both for those who are judging and for those who have the mission of actually executing the public policies, especially in the part of budget allocation. But I think that the construction of what becomes the best solution, well, it will be gradual and with time and with the dialogue of the variety of institutions that have to do with control, monitoring, and I think in the end of this process we'll be able to extract what will be the best solution for that problem. Now I'm going to open the floor to Dr. Giloa, and I will be disturbing all of you when you are ready, near to have your timer now. And now, my friend Ojilon.
All right, thank you, Francisco. I'd like to greet the Federal Court of Accounts and CEMAG for this initiative. I'd like to greet the members of this panel, Gilson, Ana Paula, Marcelo, Sabanta, the coordinator, Francisco Sergio, and I'd like to greet the audience who is watching us, especially the faculty members and university students that are watching this panel. I'm going to talk about 4 items. First, I will give you an approach on the consequentialism in the perspective of the law, and then consequentialisms in the perspective of the manager and the judge. First, let's see what the law says, Lindby says. I'm not going to mention some things that Gilson and Ana Paula already mentioned, so it will save my time, which is great. First, legislation has the goal of establishing expectation and to think of stability of the destination of the norms. And we work in the world of what has to be adopted or should be adopted as a conduct. What happens is many times the consequences of the application of this norm can go against another norm, a value that was consecrated by the legal ordering or even a rule. Article 20 of Lindby is new when it brings a practice that was adopted in some cases by the Supreme Court, by the Federal Court of Accounts, and the Court of Accounts has different consequentialist evaluations in different matters. Now with this law, the Lindby, we need to have some considerations. The problem is that the Lindby didn't give us the criteria for us to do the evaluation of consequences. So what are the perspectives? What should prevail when there are different alternatives? Which one to choose, and what is the criteria to adopt? What value will be privileged, and what is the right of the ones who are at stake to be protected in a concrete case? So Lindby didn't give any criteria to give us basis for these hard decisions. But this law, in terms of consequentialism, it comes with an attempt to offer more legal security. And in that point, I feel perplexed because consequentialism, it when Jeremy Benn created, or it has a great push with him, and then Stuart Mill, it brings the movement of legal pragmatism and legal realism. And in the United States, it must be probably where consequentialism really prospered, and there is no embarrassment for the pragmatist ones to admit that consequentialism brings legal insecurity. But they understand that this insecurity, the legal insecurity, is part of the law. It's part of the exercise of law. But because of the lack of criteria and the absence of predictability, because it varies according to the legislator's head, the legislator's mind, it brings some instability in legal terms, because it depends on what the judge will decide from his point of view, his vision of the world. So in the United States, they understand it clearly that consequentialism generates insecurity. Here, it is really broadcasted that consequentialism is an instrument of legal security, which is the opposite from the United States. And I feel really perplexed of that. In the so-called blackout of the pens and the creation of the limit, it's important to remember that the administrative law has improvisation, paternalism, decisions on their own, on the person's own interest in few cases. Take. So there is a rhetorical idea that needs to be better understood, in which it is attributed to the control institutions the stability. So it is important to have more empirical research to deepen this debate. Thinking of the quality of the public administration from the constitutionalism and the elevated number of punishment of different political positions and so on. So there are interesting points regarding consequentialism. Should we think of the short term or long term, the individual terms or collective? So these are matters to be evaluated in each case, of course. The answer will vary depending on the case, but it will require empiric data. To act by consequences takes time and money, because it depends on future scenario and not only guesswork. So otherwise we will change the criticism and the criticism of principles by the guesswork. So we need to have empiric data to have the evaluation of future scenarios. Regarding the three other points that I'm going to mention, I understand that the consequentialism of the legislator and the judge. The legislator is consequentialist by nature. They think of the consequence they want to produce, and then they write the norms. So nothing more consequentialist than the norm itself. And from this we have the importance of the legislative impact assessment. This matter is not very solid yet. They want to produce a certain result, but they do not consider other reflecting consequences that can compromise the result that they want to reach. So the legislative impact assessment is very important. In terms of budget and fiscal rights, maybe the legislation is the most emblematic one in terms of consequentialism. It's hard to see another legislation that is more consequentialist than the fiscal and budget. For example, having PPA or the budget guidelines law and the ADCT 103 command saying that the waiver of income should be taken into account by the financial analysis. Anyway, there is an alarming consequentialism in terms of the budget and financial matters. And if the legislator does not use the consequentialism, they will produce norms based on his own will or guesswork. So this is the risk that we take. So it is important to think of that. And the manager can be consequentialist as well in some cases. And I agree with Adilson, and Ana Paula also mentioned that. Article 20 is applied to the manager above all. The manager needs to be consequentialist to increment the planning of the actions, to manage the risks, to evaluate the scenarios, and for that, the manager needs to dedicate him or herself to collect empiric data, to know his or her reality. Sometimes they don't know the past of the institution that brought to the present situation where they are. So how can they think of future scenarios? It's going to be hard. So it is important to have this work on the consequentialisms of the management. And TCU always says that the main problem in terms of errors of public administration comes from the lack of planning. And here I call your attention for a strategy that is taken here and there, which is the strategy of legitimizing of fact. There is a certain situation that comes from the absence of planning and the absence of consideration of practical consequences, and then it is moved to the judge the consequence of adopting a consequentialist decision. That is a problem that is created by the manager, not by the judge. So we need to have the accountability towards the manager that needs to do the planning, taking the risk of making this risk if they do not do the planning, and demand from the judge. It could be the Federal Court of Accounts or the legal branch, something that should be considered by the manager and not the judge. And lastly, we have the consequentialist judge. As a rule, and there are obviously exceptions, but by rule, when there is a demand from the judge, the consequences of looking at the command of a norm, it's because there was a failure from the legislator in their evaluation of practical consequences, or the manager in the evaluation of practical consequences. So it's hard to see a challenge coming to the judge to having the judgment of practical consequences without seeing an error or an absence of thinking of the practical consequences by the legislator or the manager when they practice an administrative act. Of course, we can see some cases when TCU determines the nulling of a contract when the cause is from the contractor. For example, they send a false document that is hard to identify the legitimacy of this document, and they cannot interrupt the contract. So in these cases, TCU has the evaluation of consequences and with a jurisprudence of 15 years or more, and to evaluate the contract, they need to have a bidding process. But as a rule, I would say that you can see the previous failure from the legislator or the manager. What are the risks of consequentialisms? I would say first, the bad use of it to keep the legitimacy and the state of anti-juridicy, saying what the norm reads and keeping juridicity. The creation of activism. The consequentialism can incentivize activism or the politicizing of decisions without having an empirical study, and the creation of legal insecurity. And there's one more: the moral risk of 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 incentivizing wrong conduct, having the legislator using a consequentialist argument. But there are risks of not using consequentialism, because consequentialism can be good, can be useful for the judge and for the society. So it is necessary to evaluate the practical consequences to avoid the creation of disorder instead of order. So I'm about to finish. Okay, Francisco Sergio? I will finish in less than 1 minute. Or to produce a decision that is not possible to be executed, far from reality, as we see in the resolution 315 that established a dialogue on the possible determinations that the court will do in the future. And in an example, in a recent example of the evaluation of practical consequences that the court did, asked by the union, by the federal government, the decision of the plenary for transferring of funds to the subnational entities to combat COVID-19. So the evaluation of practical consequences is necessary, but it has to be adopted and carried out with moderation. We need to have the moderate consequentialism so that it will not become an instrument for legal activism or accounting activism, and it may produce the opposite result that you expected, that is more legal insecurity than security. Thank you so much. Thank you very much. Your approach is very interesting, addressing this paradox, which is the advocacy of consequentialism as something that could help bring more legal security, when in fact we can see the opposite. It's interesting, the approach that complemented the two previous ones that talked about the activity of the legislator as the first consequentialist in budget matters. With no doubt, he has the duty to evaluate, to look at the ends of what they will allocate in terms of budget. And although many times we are faced with a work that is not really based on concrete facts, the legislator, many times they want to build the public policies or to take construction work to their municipality or state without an efficient evaluation of the need of that work, and not considering the costs that will involve in the execution of that endeavor. So it's important to look at the legal rule that is produced by the legislator. After all, it comes from the first evaluation of consequences. This evaluation must be valued in the decision-making process. Now I will hand the floor to our next speaker. Wait a minute, please. Who's going to be next? Dr. Júlio Macena. Good morning, ladies and gentlemen. It's an honor to participate in this panel with my dear friend Vitorelli, Mr. Odilon, Dr. Ana Paula. Send a big hug to Ricardo Soriano. He studied with me at college. And this panel mediated by Francisco Sergio and with dear Samantha. I have a deep admiration to her. And I would like to congratulate TCU for this week, this budget week. Dr. Lucien, who is on the organization of the event. It's a very enriching event. I don't have much to add to the wonderful presentations that we have seen, but I'm going to share my perceptions on the law, on LIMD, just to complement what Vitorelli and Odilon mentioned. My eye also cannot see this world when there is an excessive control, or control is the cause of inefficiency of public administration in Brazil. I think the context where this law came, when we have a more complete analysis of the law, we need to remember the devices that were taken out of the law. And with the vetoes of these devices that President Temer did, the remaining norms, they were not very impacting. They didn't have a large impact. The practice of thinking of the practical consequences of the decisions in the controlling sphere, at least in the Court of Account, has happened for a long time. Many times, in a very forefront way, in a very avant-garde way. And people would say that it's really daring. So it was not really something that deserved compliments. But today, people see the importance of this. The TCU is an institution that really is open and open for the discussion with the managers. This law from 2015 is just a confirmation of an old practice. The technical areas, they have the openness to discuss with the managers, and if they have a doubt of if it's feasible to have a decision or not, they discuss it before. So this approach of dialogue from TCU makes me feel comfortable to say that the problem that LIMD came to resolve was not the lack of consequentialism in the Court of Accounts.
So there's a need for managers, when they're going to make the decisions, so that they don't just decide on abstract values without considering possible alternatives. The norm is primarily directed towards administrators. There's a permanent tension there between the public administrator and those who are being administered. When there's a permanent tension between controllers and the public administrators, then this tension is resolved through the intermediation of legal norms. But I see that we're talking about the administrative right of fear, and sometimes we have an administrative right of capture, especially in regulated areas, infrastructure concessions. When this happens all over the world, this is not exclusive to Brazil. There's always attempts by companies, regulated companies, to capture the regulator, because usually there's an asymmetry of information which eases this kind of persuasion of the regulating institution. So I think that we might have a context in which we want to have the administrative law of the consolidated fact, the prevalence of fact, the attempt to consolidate fact situations that sometimes might go against laws or contracts, to create situations which later are hard to undo. And then we have consequentialisms, like it was a medicine for the creation of legal security, when in fact it must be a residual criteria for legal decisions. After the application of the norms, of the whole legal framework, I have the possibility of a few different options. I can do a consequential analysis of each one of these areas. I can't bring consequentialisms to a reason to go beyond legal norms, to go beyond a legal framework, because then we will come to the voluntarism of the judge or the controller, and going, and the consequentialism gets a little farther from the legislator. They're the ones who are democratically legitimate to make these norms. So we're going to concentrate powers on the hands of controllers or judges in order so that they can decide on the way they think is best. Or they can make the controller or judges hostage to certain situations in which they didn't contribute in their constitution. So these are aspects of consequentialism which we need to pay attention to. When these devices that talked about only rude mistakes, only great mistakes, or actual facts of corruption were to be sanctioned, there was a possible declaration action of the validity of actions or of contracts against the law, or contracts with erga omnes effects. The architecture of the law wanted to consolidate situations that went against the law, and then we create a culture of, okay, it's done, and then it was very convenient for those who were obtaining results in public administration, which ended up being controlled and contested by the TCU with more frequency. I actually remember a debate in which I participated about this norm. One of the debaters said that the norm hadn't been thought of in the TCU. It was just to give economic agents legal security. It was the first time that I saw a norm that makes a technicality between the administrative and controlling areas. I don't think there's another one. I remember a bill that made this distinction, but as for a law that was actually passed, I don't think that exists. So that was a law that had the technical care of making references and making it clear that they were worried with the controlling sphere, the controlling institutions. So I believe that from the point of view of taking into account practical consequences in this way of deciding, I think that TCU already does this in a very tangible manner, in a very natural manner. Basically, we're going a little bit more than what we already did. So maybe in the decision, there's just more of a explicit nature to these process, which is helpful because it helps to consolidate this practice. And I don't really see big challenges in the norm for the exercise of control, considering consequentialism in this complementary subsidy giving dimension when applied to the control of concrete cases. Let me just see if I haven't forgotten anything that I wrote down. No, I think that's it. Everyone referred to this recent decision in relation to budget issues, the nature of resources that were transferred for the pandemic, transferred to subnational entities. There was a lot of discussion of the LINDB in this decision, and it was very clear there how there was an important debate of the federal government with the TCU about the practical consequences of the TCU determined correction and about the prospective nature of this correction. There was an argument for the federal government that the TCU was retroactively changing its understanding when it determined that there was a recalculation after the second half of 2020 as for the net revenue. But it was clear in the decision that this recalculation would only have impacts in 2021. Therefore, the decision that was taken in December was in accordance to this LINDB directive guideline to do modulations in relation to future effects. I don't want to go any further, Francisco. I think that talking after Gilson Ojulon and Ana Paula is actually, for me, it was a privilege, but I don't really have that much to add, so thank you very much. Dear Dr. Judo, thank you so much. This issue of the court is being something, an institution that is based on dialogue is in our DNA. Everyone who sought out the court to try and deal with a certain problem, a certain difficulty in interpreting a law, or let's say, or in trying to apply a public policy, they may have been surprised by the reception they received in the Court of Accounts, because the Court of Accounts has its traditions, and Resolution 315, it really made this even clearer. And Decision 561 of 2021, and I think it was a good thing to consult, to look at, for those who want to see in practice a decision that had to do with the LINDB Article 24 in relation to effects. So, finishing up this first step, I'd like to open the floor to Dr. Samantha Dobrovolsky so that she can give her share her thoughts on this theme. Well, good morning, everyone. First and foremost, I'd like to thank Semagi for the invitation. Leonardo Luciani, thank you. I would like to thank Francisco Sergio for his presentation. I'd like to greet all my friends and people who are all my colleagues here in the bench. And also, it's hard to really add anything else because this team has already been discussed in such a comprehensive manner by Gilson, Gelon, Ana Paula, Marcelo, people who know a lot about this topic. So, as far as I'm concerned, I'm going to make maybe a less of a technical approach, a little bit less of a consequentialist approach, and try and insert this topic into a discussion that encompasses all of legal practice. I think that Ojulon mentioned this quite well on how this issue was inserted into legal theory and into this new LINDB legislation, which is a law. We have students here in the crowd, so in the audience. So it's a new law for the interpretation of norms in Brazil. It changed the introduction of the civil code, which was an important legal framework independently of its origin, of the time that it was developed. But it did actually, what was missing as a lot in Brazil was actually just a good reading of it. Reading and practicing legislation, which is already there. It's been there for a long time, and they're really interesting in a certain way comparison to what's being done in the legislative world today. Unfortunately, there's a lack of debate, which has also marked the change in the law of the introduction of the civil code to the LINDB. There was a lot of vetoes which minimized the impact. If without the vetoes, maybe we could use the LNDB. There would be a great discussion of constitutionality, but this does not guarantee results or that the results will come in the adequate time. And the lack of debate, a lack of going in depth technically with the various different fields, the various different groups in law, and the lack of debate with relevant sectors in civil society. By relevant sectors, I mean stakeholders, people who are interested in that because they will be affected directly, be it people who are in public administration, people in companies that provide services to the state, and of all the institutions which make up the control institution group, which is divided into a variety of different public agencies, a variety of different institutions. But even then, it's not a hypertrophied control. There's a multiplicity of these agents and spheres of accountability so that we can repress abuses and infractions. And this multiplicity, it seeks to guarantee, it's not always going to guarantee, but it seeks to guarantee the capture of the controllers by the controlled. But this multiplicity seeks to optimize the possibilities of control, allowing it to overcome certain failures in the exercise of its functions by one or another of the institutions. And there's also technical issues for each kind of procedure. A penal process might be a lot longer, and it allows for a lot more of procedural problems than in the administrative phase. And each one of them is characterized by specific objectives, specific sanctions, which complement each other. And despite being something very serious for the people who are being accused of something, of being sued, well, for a long time now, law has been practicing it. This has become even clearer lately, and with the issues that the anti-corruption law has brought about, and the fiscal responsibility law as well, which is the adequation of penal execution of sentences. No one's going to be punished 2 or 3 times with the same sentence for the same crime. There's a method in law, even though it seems like in our internal legislation, like we are in a legislative asylum in a certain way in relation to certain issues. But we have hermeneutic principles, and this does not depend on LINDB. It didn't even depend on the law for introduction of the civil code. This came from Roman law, the premises of interpretation, and of this whole line of studies of philosophy of law and theory of law, which was dedicated to seeking a solution for this impasse, which it seems is constitutional to the very nature of practical law, which is to bring an isonomic, coherent solution based on the words of the law and of the legislation, which is never complete, which is never absolutely clear, and which you don't always get unequivocal meaning. And so it's a human work. It's based on language. Language is not a single unequivocal thing. Due to social media, today we live a moment in which there's a lot of discussion around the meanings of the application of words. So if we take away the fact of ideologies and polarization, the current moment throughout the world, a lot of this has to do with the application of language, the verbalization of expressions, which can be misinterpreted, which can be distorted. This also happens in legislation. Legislation, even though it might be technically created, it can't always just close off all types of meanings or even imagine all the consequences of its applications or all the situations that it should cover. Situations will crop up with technological innovation, with social changes, and a law that mentioned, for instance, civil marriage between a man and a woman. It's not sufficient to deal with the issue of homoaffective living. This is an example that has nothing to do with our specific thing, but it shows that just keeping to the very words of the law or the legal command to study consequences does not solve the practical problem. Oftentimes, it doesn't solve application. Application must seek to be fair, must seek to be pragmatic, because law exists to solve problems. If it wasn't for that, there wouldn't be lawsuits between private parts or in discussion with the state. But it is necessary to accept that there's a certain tension between what is fair, what is legal, and a certain impossibility of being able to handle all the different content, solving all of the problems beforehand, and avoiding conflict. So it seems to me that LINDB with Article 20, in the way that it ended up being applied when read together with Article 21, it brings a necessary contribution based on the moment that we are living. Since we have abandoned a tradition, a legal thought tradition, a more distant thought tradition coming from Roman law, a study on the premises and how to interpret the law, and maybe this is due to the massification of lawsuits. There's a series of impressive lawsuits, and this is also an administrative level, so maybe we need to stopping and studying. To study each case is a little bit harder. Solutions become solutions like they're almost industrial production line solutions, and this ends up lowering the quality of the work. So it is important that we remind ourselves that when we are arguing for our decisions, that all of us who are in the system, from the lawyers to the prosecutors who give opinions, up to the decision makers, be it in the administrative sphere or the judicial sphere, all of them have arguments. All of them need to argue and to try and prove their premises and their position, and try to convince the other stakeholders in the process. And as it was well reminded, the first person who had to argue better, and I'm going back to the beginning, is the legislator. The legislator have the obligation of giving a certain density to the Constitution when they complement this with legal orders, having insight, social benefits, the public interest to which the law should aim, and specific interest if there is a need, if maybe there's a specific need for a sector, for a minority, for a segment, and also take into account the practical consequences of their acts. And it's not for no reason that one of the ways to control the constitutionality and the quality and the validity of a law is through its if it's reasonable or proportional, which are principles that we can take as being synonymous or making a quick distinction between a concept of German origin and one of American origin, but they contain in and of themselves the issues of adequation, the need for that legislation of that measure, and the stricto sensu proportionality and reasonability. So that's something that is reasonable or proportional, and as being reasonable, they have a rationale, intersubjective rationale behind it. It will be understood by everyone as being reasonable, if so demonstrated. And this mobilization, first and foremost, comes from the legislators themselves when they are making their laws and producing norms. So laws that define public bids, the allocation of budget resources, and the budget law itself. I think that after the Constitution, if it's not the main law representing the budget or the democratic system, I think it actually really is the law that consolidates the democratic principle, because that's when the state is going to consolidate its premises and priorities and allocate resources. And in fact, in a certain sense, the state exists to guarantee that the common resources, public resources, are applied in priority needs. And when you have something left, you get into other needs as well, according to the discussion that's democratically done by legislators. So it seems to me that also in budget legislation, which was one of the points of our panel today, in budget legislation, in the definition of allocation, and then in the execution and in monitoring of the execution of the budget that should be done in relation to responsibility, to fiscal limits or fiscal allocations, which are useful and not irresponsible. maybe not everything has to be useful in a very restrict sense. There are certain issues which are a little bit more complex in the application of resources. Otherwise, we wouldn't apply public resources in culture. We could discuss what's more important, culture or health. But it's important for us to have a very explicit debate, as Adilson said, about the parameters of allocation in consequentialism, justifying the reach, the limits, the ways in which this should be executed. So, the first command, even though it's not there, is for the legislators because it comes from the Constitution itself, from the very role of the legislative power. After that, I think that the LINDB obviously is aimed at the public administrators. If the administrators who are applying the resources and executing the public policies that they can define, or they maybe have to meet something that has already been defined in its administrative environment, be it through a municipal, state level, or federal legislation, they have the obligation of having a technical, legal base for their administrative decisions. So just like they have to be careful in making the documents behind a public bid for construction or for service, it's important to, like Edilson said, building a portico or childcare. Well, you need to have an analysis of consequences, of practical effects, of the impact in resource allocation, the impact of that in that specific society, in that specific community. Managers and administrators would have to promote a significant quality gain in their decision, considering that Brazil is a huge country with over 5,000 municipalities and with a lot of disparity in the way which management actually happens. So the first people who are being aimed at by this norm are the public administrators, and I think that the goal that has been sought out, and I think basically is to try and control the very controlled organisms and keep them a little bit more in check. Well, maybe public administrators are maybe trying to give a little bit of a rupture in relation to their obligations. That's what it seems to me that happened in the development and discussion, which was not a very wide discussion, in the sense of involving a lot of different sectors. Maybe it might have been in depth in the group that was dealing with it, but it was not a wide-reaching democratic debate, and it actually resulted in the opposite of what it intended. The people who are being aimed at are the public administrators, because only based on what they did or didn't do is that administrative control or judicial control is going to act. And it also seems to me that it's very curious to separate the judicial and controlling spheres, because in fact there is a separation. The acting of public administration control by the very TCU is an administrative sphere of control, just like internal control. This is external control, and there's also an extrajudicial actions by the prosecutor's office, which also control all sorts of legal issues. However, all of this, which is in the administrative action, which is in the same level of the public administrator. No, they're also public administrators. They're on a different level. They submit to the same principles, limits, laws, ethics codes that others do in administration. And all of this administrative action, be it in administration or in monitoring, including control institutions, it is submitted to judicial control, which is final instance of control, which is the highest level of control, which is the control by the judiciary power if there is any infractions of the law, and of debates about this. So it's curious how the law makes explicit, maybe in a less technical manner than they should, the different perspectives in the action in behalf of the state. And already finishing up, because I've lost my time. I don't know how much time I've spent.
In spite of this explanation and the search for a certainty that the outcomes of the decision of the control institution and the legal institutions will take into account several difficulties found by the manager. And as a matter of fact, it was done already. The Federal Court of Accounts itself has decision in old cases that in which there was an action of corruption, and the contract was not undone because it had been done. The contract was occurring for around 10 or 15 years. So the point of adequacy, proportionality, based on the reality of facts and the difficulties and effects of undoing an act is worse than dealing with the consequences of illegality. It existed. It has existed in the public administration of Brazil and the judiciary branch. It cannot be incentivized, but it is not something really new or a need for the legislation to have a very little technical manner. What we're looking for many times is try to guarantee a concrete and unified result to the problems. But the problems are not absolutely equal. We will, in terms of public management specifically, we will not have something objective to challenge simulated action. Of course, we will have to apply an index of correction of the salary of a functional category, and that should be the same to all. And if there is a prior decision, you can correct it, and it would be a very objective and concrete situation. But other situations involving construction works and public policies, which was the main theme of the blackout of the pens, the so-called blackout of the pens, and this type of discussion that involves other types of values that are very important, and they are in the Constitution, such as the advocacy for the environment, they will not be solved only with the study of consequences of that act in the moment of control. Because every time one door is closed as the act that you're doing in the monitoring process, and we should verify the concrete effects, many possibilities of reasoning and understanding will be open, possibilities of effects that were not predictable in the moment that the decision was made, such as construction work, but others that were quite visible but were not considered. And you always have a certain degree of uncertainty. I wouldn't call it insecurity. Odilon talked about insecurity, legal insecurity, when another door is open to analyze several uncertain aspects, and they will challenge distinctive reasonings from the person who is applying the norm. So the vagueness and ambiguity that are in the legislation, because they are part of the language, the difficulty of the legislation to presume all the possible application scenarios, it is kept, even though you have a rational justification and parameter as the measure of the consequentialism can be understood in the LINDB. And it is a very, very open criteria, as Adilson mentioned. So we should have a series of limits for this criteria. And even these limits and conditions are based on a sufficiently open term to find consensus. So more than trying to find a closing in the meaning, and me as a manager, I will be evaluated by the criteria that are clear, and sometimes it's not that clear. It is important to have transparency in the decisions, publicity of the motivation, including the consequences to be avoided and to be sought to. It is very important. And an expressed innovation, because this obligation already existed, but now it is expressed. I think it's relevant in our society, which is a society that has a deficit of legitimation in the application of law. But to consider all this, to make it happen, we need to have an honest public debate when the economic issues have to do with the allocation of the allocation of large amounts of financial resources on policies that are similar, in which the choice is not easy to be done. And besides the expressed motivation and transparency, we need to have a public debate so that the application of the consequentialist principle, I would call it this way today, this consequentialist command, which is not a rule either, it is more of the American pragmatism and of the very violent use of own will. So a public debate is important in these relevant issues that will affect a bigger community. Professor Samantha, thank you so much. It is interesting to reinforce what we see in the prima facie situation. And it's interesting to see that there should be an improvement on the budget governance aspect. The legislators, the people who are in charge of making the budget in this game of powers of different stakeholders to make the final product, we should have a product that has a better quality. And from this, the public management would improve their work in the sense of making the law happen in practice. Now, for the next part of our panel, I would like the organization of the events to show the result of the survey that we did online. So the question was, what do you prefer as criteria of decision in terms of in fiscal and budget terms? So the predominant option was that to assess the decision criteria to be adopted according to the concrete case to be judged. 4.4 people voted for that. So it's like a reflection of all the others. The second one was if the consequentialism is adopted as a main decision criteria of the judge in fiscal and budgetary terms, what will be the consequence? Most of them answered that it will increase the casuistic decisions, and therefore it will increase the legal insecurity in line with what most panelists mentioned. Now let's see the next one. The question about the consequentialist dimension of the bench member activity should. Most of them said that it should. The work of the bench member would identify the possible meanings of the norm, respect the fundamental rights at stake, to choose the solution that produces better results for the society. So most people chose all these options, which has to do with Dr. Samantha mentioned that we go back to Roman law to justify this argument. Now the question is, in the administrative sphere, when the public management motivates the decisions with the public interest, they need to assess the practical consequences of the decision, and most people said yes, the public manager should evaluate the practical consequences for the discretionary decision. So it's prior to the LINDB. And also It is in the Constitution. Another question. In your opinion, the legal decisions with billionaire budget impact in the case of the court order debt, should they observe the practical consequences in the LINDB? So some people answered yes. We should observe the impact of the legal decisions. Some people say it's not possible to know that. There are some suggestions. For example, we propose the reflection on the public debt, refer to the payments, to create compensating measures, the methods for evaluating the court order debt. Also, in my opinion, the practical consequences of the decisions were not observed in the LINDB. So I would like to open the panel for discussions, for comments, for whoever wants to comment on the results of this survey. Dr. Dillon, would you like to make any comment on that? Well, I'd like to comment on the answer to the first question. On what do you prefer as a decision criteria in terms of fiscal and budget matters, or between being positivist, consequentialist. Most of people think that the judge should think of the concrete case. The answer is completely harmonic to what the best doctrine refers in terms of not understanding that there is a unified criteria for decision of all cases. There are different criteria that change according to the nature of what you're discussing and the circumstances of each case, which means that some cases will require consequentialist evaluations and consequentialist decisions. Others, the judge will give preference to the consequences, the decisions that were referred to the norms. Even the pragmatists such as Richard Posner said that. He says, I'm pragmatist, I'm not consequentialist. And he explains the difference between two things. There are some cases in which I will not consider the practical consequences, but I will give preference to what will prevail in the case. And this is what our audience chose. So, as Samantha also emphasized on her presentation. Dr. Deus, do you have any comment? What caught my attention in the survey is that most people, as we mentioned, as Odilon and other colleagues mentioned, is that the consequentialism does not increase the legal security. It can increase a set of parameters for a decision, which is good. So it is better to increase the precision of the decision, generically speaking, the justice of the decision, the adequacy of the decision to the case, than to increase the security. So it creates one more tool for the judge, for the one who will make the decision, to have this fine tuning on the decision to the circumstances of the case. But the cost of it is a bigger unpredictability. We have a series of parameters, as I showed to you, that can be considered as a consequence. And it is interesting that the audience also realized this, and they showed that, as a matter of fact, it's not that there is no contribution. I am favor to this device, and this law brought an important debate. But the problem is the generic character of the decision, the creation of this law, and also thinking of the action, the declaration, as Julie mentioned, which is really outrageous. And there was a veto of the from the president at that time, but in some circumstances and given some scenarios, the consequences must prevail over the strict reading of the legal command. But these scenarios are very little predictable ex ante. So if you look at this device thinking that it will bring legal security, it's actually the opposite of it. And the audience understood it very well. Dr. Ana Paula, do you have any contribution regarding this survey? Well, it called everyone's attention the same question, and the reflection that everyone does here is for the supposed disease identified if this medicine is the most adequate. The value that permeates several parts of our constitutional text very clearly is the creation of several mechanisms. If this perceived value should consider a universe of supposed offenders, and I think it's interesting in this device is if the proposal is to preserve our value to provide legal security, the punisher was elected. The principles were elected. So the discussion is broader, and it's not something technical. The punisher were the abstract legal values. For this punisher, maybe an attempt to limit the use of an interpretation mechanism. I'm talking about the control institutions and the judiciary for that. It is totally legit. It was taken as a problem, and the solution was something that shows to be not very trustworthy as an adequate medicine. So the device is very interesting. It gives preference and privilege to something that I think it's really Republican, and it's very old, which is the need of the motivation, but it's not as efficient when it restricts the use of the abstract values by using a mechanism that is very not trustworthy when we think of the reason why the problem was taken into consideration. In some results of the survey, it was quite clear. And also, lastly, I would like to thank and witness what was addressed here as this stance of dialogue in the teams of TCU. It's really really interesting. And as I understand, it should be the stance of the medium person in the public administration, and to give preference to the responsible fiscal management. The bureaucracy today that deals with this topic could have reached a certain maturing level if we didn't have this very receptive stance from the controlling institutions. So thank you so much. On behalf of my institution, our doors will be open to you And a message for Dr. Julio. Dr. Julio, please. Well, what was clear to me from the survey is the risk of casuism, that the consequentialism can be an instrument for construction of casuism, that to justify decisions that are not according to the legal norms. So a space of opening for the judge to conform the decisions to something that he or she thinks is best or convenient, many times ignoring explicit consequences that are in the norm. So there is the explicit demand of nulling an act. In some cases, the interested part that wants to see prevailing a certain argument, and a certain contract cannot be stopped or nulled because it generates jobs. There are 700 workers in this construction work, and arguments like that. They are generic arguments of generating employment and income to justify that to justify that a work that used much more the money that was supposed to use, or even the payment of bribes and things like that, just using this argument of practical consequence. If I stop the construction work, there will be a loss, people will lose jobs, at least until the construction work will restart in different conditions. So the consequentialism, if it's used in this loose way, it really gives place to the decisions of the own opinion and will of the judges.
Anything else, Samantha? Well, just to complement what they said, I agree with everything that my colleagues just said. I think that the audience was very attentive. They're really in harmony with what we were talking about in the first part. And it seems to me that this issue of abstract values having become enemies is interesting. And it has to do with what Julio just mentioned. This tension that exists between abstraction, constitutional abstraction, that model of society, that self-image which in thesis society gives to itself in creating a constitution with values and principles that should guide beyond the most concrete commands in the Constitution. These values and principles including legal security. That's not the only principle, because we have also the principle of legality, of morality. That's also important. How does this make itself concrete in practice, and how this relates to certain situations which might be considered hard or tragic situations? These are tragic cases in which the consequences really need to be taken into account, so that we can see whether a public administrator acted recklessly or in bad faith, or was just incompetent, or given the circumstances he didn't have and they didn't have enough options, and then something unforeseen happened. So nowadays we live in the time of the unforeseen, the pandemic. So some decisions that were taken right before the pandemic can lead to a huge inefficiency, a tragic inefficiency in administration. So all of this needs to be taken into account. So for this, law is useful. Law is always going to be useful, especially if we deal with it in a more constructive manner, and then together with all of our legal order, starting with the Constitution. But we didn't need the law, because both the administrator that applies the law and becomes an infractor, the judge also needs to apply the law to concrete cases, adapting circumstances and abstract value to the practical, effective circumstances in which an act is practiced. So the law is welcome in the sense of reinforcing this argumentative obligation, but it just makes explicit an obligation which already existed before, which does not solve issues such as a hydroelectric power plant that was made in a certain place in the country, and there's no rain in most part of the year, that impacted traditional communities, the environment. And if we evaluate the concrete conditions that were already visible at the time, it's not possible to actually sustain this without punishing those people who actually defined and decided that this should happen. So there are certain cases in which the legislation goes against that which actually motivated in an unclear manner the change in legislation. So I think that the big challenge we have is how to balance the needed examination and analysis of effects, of virtual effects of an action, and of all possible scenarios, so that it might be to analyze whether you need a legal framework in relation to this or not, is the issue of respect to values and principles, which up to a certain extent are even superior. They are abstract, but they have certain normativity because they come from the constitutional text, and which, based on these values, we can guide community life as a whole. I'm talking maybe in very abstract, hypothetical terms, maybe even illusory terms, but it is necessary for us to dream. And I'm mentioning these abstract values which guarantee a legality, a state, and in a society which is better managed, and with a pluralist society like we have that is more pacified. All of this demands a balance between making abstract values concrete, and this process of making them concrete sometimes is done, well, it is concrete in and of itself, but for those who are interested in consequences or in defending their actions, even if they were done on the margin of some principal commands, it's not going to be very welcome, because they're going to have a degree of abstraction or of less normative densification than those which would please those who are oftentimes interested in pretending to have these conduct parameters, especially in the public environment. So I think that this tension is expected. We need to look at the effects no matter what, but we must also value normativity, legality of these precepts which actually support the whole social structure. At that moment when that stops existing, society in and of itself will be ruptured one way or another. At least that's what it seems like to me. Wow, very well. So now I'm going to ask our support to give us the second block of the survey, since we are heading towards the final stretch. In your opinion, are judicial decisions with huge billionary budget impact? Well, I think we already had that. Okay, so considering the budget cycle, do you understand that consequentialism can contribute to the improvement of the budget and to a larger fiscal discipline? If so, what would this contribution be? And so I can't really see the first answers there. I understand that it wouldn't understand for the improvement of budget and the fiscal discipline. Or yes, it would contribute in the sense of bringing more control for responsible fiscal management. Someone else said no, someone else said yes, because in that way decisions could be fairer. Consequentialism can contribute up to the measure that decisions without basis in reality and that go against the interests of society can be considered. However, casuism needs to be this casuistry needs to be prejudicial in a budget manner, because it might lead to legal insecurity. And yes, the manager should measure consequences. This leads to the improvement of budget planning. So we're talking about the process of budget development, up to which point those people who have that mission would have the increments of evaluating consequences. Do we have another question? How do you see the TCU decisions in terms in fiscal and budget terms in the consequentialist perspective? This is a question specifically about our action at the TCU. I see that there were significant changes for convincing the judges. I think it's still very much incipient. And someone says that our situation is balanced. They keep fiscal norms without serving the balance of the evaluation of public policies. Here it also says that our decisions are still need to evolve, but are in a good path. Their decisions should be considered in the vision of practical evaluations. This also has to do with Dr. Samantha said, we need to respect constitutional principles. Here on the side, can I see this answer? If each consequentialist or positivist move that is inclusive looks for the election of its favorite creed or favorite right, will have a problem for the legal state of human rights in its most basic elements. And then it says the DCU's decisions are national parameters when they usually keep in line with the best practices of external control. Anything else? Do we have anything else? And here, indicating two words, how the consequentialism foreseen in the 20th article of the LINDB can affect budget credibility. The biggest word that was mentioned was legal insecurity. We have insecurity, adequation of measures for predictability and stability. So I'm now going to open the floor to you to comment on this second block of things in our survey, starting with Dr. Ojilon. Your mic. Thank you, Francisco Sergio. Well, it really catches my attention. The one that caught my attention was the question about constitutionalism in the budget part. There was some divergence in the answers there, but I'd like to highlight those answers which were in the sense that yes, consequentialism may contribute. I do this because I remember having heard throughout this week in this amazing event that was developed by the CU, more than once panelists highlighted the absence of a more intense discussion on resource allocation criteria in the budget, specifically with the lack of balance due to the high number of Congress amendments. So, I understand that this goes against the evaluation of consequences and in favor of voluntarism of a certain personal interests, which may not be aligned with society as in relation to its demands for their fundamental rights. So I understand that in this sense, the consequentialism or the evaluation of practical consequences in the development of the budget would give a significant contribution, and I think the TCU itself and organized civil society itself can also do this. Well, they could give a very significant contribution to the increase in discussions that come before the budget law in order to give more subsidies, empirical data, and in the case of civil society, even their anxieties, their legitimate needs, so that this was debated and considered in the development of the budget, because this has to do with the practical consequences. Therefore, in this sense, it seems to me that consequentialism would have an important contribution to the increase in the quality of the budget. Thank you, Dr. Ejulson. Can consequentialism contribute? I hope so, but I fear not. I would really like it that we would be able to better evaluate this. I think that the budget issue is the one that should be the most consequentialist, keeping in sight that there we have a decision, an allocative decision for the future. And pondering future consequences in the budget is fundamental. And that's not what we have seen throughout the last years with secret budgets and secret transfers and the expansion of Congress amendments and the expansion of fiscal irresponsibility, especially in subnational entities. They are successively refinanced by the federal government, and they do not fulfill the obligations of their financing. And once again, they are protected by the courts to prohibit the suspension of transfers. So unfortunately, I think that we have been living in an era budget meltdown, which is just terrible, and that maybe I think that if being optimistic, I think consequentialism could contribute a little. But I think that the problem that we have in this dissolution of budget premises over the past few years is really very, very serious. And if not consequentialism, we need to seek out a solution somewhere else, which is very important. Dr. Ana Paula, I'd like to congratulate the court for the way in which the theme is being discussed in relation to consequentialism, because it's interesting that when we reach this question, for instance, we'll see that, in the discussions, some colleagues had to do with the authorization of the consequentialism in the legislative area and the device that is aimed at the public administrator and the exercise of jurisdiction, be it in the administrative sphere or the judicial sphere. It's very interesting then to consider the eventual usefulness or importance of consequentialism in the process of developing the budget, which is purely and simply, in my opinion, one of the most important laws that we have. Yes, I think that it's extremely interesting to have the logic of consequentialism. It is evident that when you do resource allocation in a restrictive scenario in which we don't have enough resources, then you are defining priorities. So it's not enough for you to have goals in the definition, because sometimes when you take a look at the budget law as a piece in which we foresee revenue and authorize expenditures, it looks like you're only taking care of the goals. And consequentialism would add to this process exactly an analytical evaluation about this decision, the possibility of society participating or having control over, well, let's see, when I allocate a percentage of my fiscal restrictions on healthcare, why didn't I do this? What would be the consequences of doing less in education? So in this perspective, consequentialism would add the need that you don't restrict yourself to the shallow perspective of what we understand as the budget. What is the budget? It's an authorization for a certain goal. No. The justification for that goal and the justification for the distribution and allocation of resources, this will allow that certain niches in society, which we know have a high level of maturing. Our dream is that everyone was very mature in the sense, and that everyone was eventually able to use such a refined information, and any justification of decision is important for the Republican principle. So if you allow public assets to be treated with transparency, certainly that's something desirable. And I would hope that we as Brazilian society would be prepared to absorb these information, this data, and analyze it. And I would like decision makers to adopt this as a methodology inside their methodology, inside their decision making in relation to the things that to the most important issues we have, which is budget allocation, public budget allocation.
Excellent. Dr. Julio, please. Dr. Julio? I'm back. Yes, I'm back. I'm back to the room. There was a little interruption here. But here I am. The floor is yours, Doctor. What caught my attention was the evaluation of people when the TCU decides on the fiscal norms. This matter is something that we decide as thinking of the consequences of a decision in another fields. I'd like to congratulate the Secretariat of Government Macro Evaluation that referred to this topic with a with very much discipline, very much technical consistency. Alessandro is there. He's the leader of this secretariat. It is a very competent team, and it is responsible to provide information to the justices with technical elements to have consistent decisions, which is the opposite of what we saw in subnational courts in terms of interpretation. I would say consequentialist consequences of the laws, saying that those financial funds would allow to hire doctors and teachers, and it deteriorated the situation of the states of Brazil. So TCU has been very strict in terms of the principles of the fiscal disciplines and adherence to the law. So the opinions of the audience is the same as mine. I think it is a way to acknowledge the work that TCU has been doing. And I'm going to have a provocation to Odilon, because in the text that is regarding the decision between the consequence of act, consequence of rule. One thing is to decide on specific acts. Another thing is the adoption of rules that have complex systemic impacts. So saying excuse me to Francisco, I'm going to give a provocation after Samantha, all right? Dr. Samantha, floor is yours. Well, I don't want to be redundant, so I will get the talk from where he stopped. Well, the comments of the audience are very good because they continue what we have been debated, and they have provocations showing that people are paying attention to what we're saying, and also provoked by the questions that were in the survey. In the budget aspect, thinking of the difficulties between adequacy of the abstract principles with concrete choices that will result in effects that will benefit a majority or a minority in a specific sector, or a political issue that is not to be mentioned but will be extracted from the budget, is the court order that if the court order that represents the payment of a debt of the government, not very rarely and included in the process for years until there is a final judgment, and it has to be executed, this payment has to be done. If it's not related with legal security and also basic rights for the citizen, the citizen had a debt to the state, to the government, that would have a negotiation relationship, or a pensionist, or a worker. So the character of this ruling is very clear. The person wins this lawsuit, and it takes years to be paid. But if the payment of a debt that is thought that is decided to be correct, and if it doesn't meet the legal security in a proper sense, and as we make justice in a very basic sense, I don't know what will be will be done. And again, we are here facing this issue. Do you pay the court order debt that are from very past management, and I have to get the resources from my project, my current project, to pay and no debt? It's the same thing as the basic budget. When people say there's no funds for fixing infrastructure problems, but when it rains, everybody remembers the sanitation. So when the managers do not like that very much in Brazil. The question is, how can we equate this issue? Because you can pay for this court order debt. We're talking about billions of reais to be paid. Of course, we need to remember the fiscal responsibility, but we can say that I'm going to cut it because it's a large amount. But if I had paid it 20 years ago, it wouldn't accumulate those billions. So people say that if I don't have this money, I cannot say it is fair. It is also a very common argument in Brazil. So how can we equate the issue of fulfilling the legal security point, and also paying something now instead of waiting for 10 years when the amount will be of trillions, and at the same time how to meet an immediate economic capacity of the state? I'm thinking of the economic capacity of the companies and the payment of the agreement. How to meet the imperative complaints that would demand allocation of resources that could be taken from part of the payments, if that's the case. How can we do this equation of the consequence of an act and the immediate consequence, and the consequentialism of rules that is based in legal security? Because it is the argument to adopt consequentialism in Brazil. I don't have this answer, all right? Well, Odilon, I think you have to answer this question. Thank you, Samantha. You were provoked by two members of the panel, when I have to address this answer to you. I'm thinking, what did I do for Julia and Samantha to be punished like that? But that's okay. We will not lose our friendship for that. Well, this expression of consequentialism of act and of rule was not created by me. I used it respecting the credit. The expression comes from the philosophy of the studies of consequentialism in the field of philosophy. It was very much disseminated in the first moment. There are different studies on that. The consequentialism of rules, in more popular terms, have to do with the systemic consequences. The consequentialism of act has to do with the consequences in the concrete case. The rule consequentialism, or in the systemic rules, have to do with the interference in the practice of the act consequentialism. Can you practice the consequentialism of act? Yes, but you need to see the systemic effects of having exception of the rule and providing a different solution, a casuistic solution, in a determined process. If there is the compromising of the systemic consequences, the solution is not good. But if the solution for the concrete case is fair and it does not compromise in the systemic point of view, if it does not compromise the system, it is feasible, it is good for the case, and it can be adopted. But if it's good for the case, but it compromises seriously the system, although it's good for the case, it cannot be adopted because it will have negative repercussions to the system, which means it will influence other cases in the future. So this is how it works, how the philosophy works when it refers to the fact of act consequentialism and rule consequentialism, which is one of the perspectives of analysis of consequentialism in the field of philosophy, which ended up being ported to the legal consequentialism. Now, the 1 million question that Samantha asked, well, I'm curious about the answer because I don't have this answer either, dear Samantha. Thank you so much. Well, excellent. Then, since we are about to finish our panel, I'd like to hand the floor to each of you for your final remarks and for us to end this wonderful panel that was very interesting, very useful for the ones who will continue the studies of the budget week. I'm going to follow the order of the panel, so I'm going to hand the floor to Dr. Adilson. Well, thank you, Francisco. I'd like to thank you all. It was a pleasure to be here with you, with Ana, Samantha, Dilon, with Julio. And I'd like to thank Luciani for inviting me for this panel and knowing that the TCU is ahead in all these debates. I remember I participated in another event in the moment that the LIND was created, and we were having successful discussions when the President Temer carried out this law. So it's interesting for us to debate this topic, and we see some evolutions. In some aspects, our forum has been successful and was able to build a discussion that is different from the one that guided the original elaboration of the text, which is not the one from the one who elaborated, but it belongs to all the interpreters. So it's interesting to have this space for discussion to create other ideas regarding this text. I'm available to you of the TCU to continue discussing on that. Thank you, Dr. Dilson. I hand the floor to Dr. Ana. I would like to reiterate the thanks to the Court of Accounts for the opportunity. Thank you, Luciani, for this opportunity. And I think my intention was to have similar considerations as Adilson did. I think the proposal of discussion here was, by its essence, an aggregating one. It enriched the discussion because it brought the opportunity to bring different perspectives, remembering that although we know that the context in which the text was maybe discussed, this is one of the criticisms that we have, and it is understandable that it will be disconnected from the context. And we have the duty to add value and to make this device more dense, to provide meaning to it, and we have the duty to have conversations and try to somehow to bring to life the purpose of this norm in a systemic way. The design of the panel was extremely favorable. Because of this, it provided distinctive concerns. So to me, it was an honor to be with you all, and you can be sure that I learned a lot with you. And I wish you a great day, a great afternoon, and see you in the next opportunity. Thank you, Dr. Ana. Dr. Dillon, floor is yours. Thank you, Francisco Sergio. I would like to thank you for inviting me to participate in this important panel. I think we are starting a new path for building uh, dogmatic and a culture of work considering consequentialism. It, with the norm, it imposes to all of us the reflection on this topic, and that's what we're doing here. So this is the merit of this panel. I would like to thank my colleagues, the panelists. It was a great honor to meet you, to participate in this panel with Adilson, Ana Paula, Samantha, Julio, and Francisco Sergio coordinating this discussion. I would like to congratulate TCU and CEMAG in the person of the current leader of the Secretariat, Alessandro, and Luciene, who has worked to the execution of this event, and Leonardo, who is the one who is the leader of the External Control Secretariat, but also was a leader in the Secretariat of Government Macro Evaluation, doing very consistent works in this fiscal and budget subject. I'd like to thank the audience for still being here with us, although we are at lunchtime. And to me, it was an honor to participate in this debate. Now, Dr. Julio, Marcelo, Dr. Francisco Sergio, thank you for being the moderator of this panel. It is a great honor to be here with Dilon, Adilson, Paula, Samantha. I learned a lot with you. Congratulations to CEMAG and to TCU for organizing this event for the whole week. When I was invited to the panel, firstly I thought, in the budget week, we're talking about consequentialism, but I think it has to do with the decision of the court regarding the financial resources of the pandemic. The interpretation of TCU according to LINDB, it provides a good discussion, and it will be part of our everyday life in all the fields of the budget segment. So I congratulate the organizers of the event and thank you for the opportunity to be here. Dr. Samantha, and thank you, Dr. Julio. Dr. Samantha had the privilege to be the last one to speak. It is a privilege because I have such an exceptional, such an incredible panel here with me. I would like to start thanking the participants of this panel. You taught me a lot, and you made my task easier because I was the last one to speak. So I'd like to thank Ana Paula. She's so gentle and objective in her remarks. Adilson, my friend, my colleague for such a long time. He is a man of the doctrine in different subjects. Marcelo, a dear friend, a dear colleague from TCU. We have great conversations along with Luciene, who is the one responsible for my presence here. I admit that. Francisco Sergio, congratulations for moderating this panel in such a good manner. And I congratulate the Leonardo and other organizers of the panel and the event. This discussion was very interesting because although I highlighted the criticism on the adoption of the consequentialism and the LINDB in the very beginning of it, the very creation of it, which was not very democratic in the form and in the content. Once it is done, this legislation has its own life and can be interpreted in a smart way, in an intelligent way. I think that's what we proposed in this discussion. and it has been done in the scope of the Federal Court of Accounts, which was the most interested one. So the law came to stop the amplification of the competences of TCU, which is part of the controlling institutions. They go through this type of constitutional organization. There are some mistakes, but there is a large reaction. And in Brazil, in the past years, the reactions have been out of measure. They have been in a culture of irresponsibility. I wouldn't say impunity, because this term is very much mentioned, but irresponsibility, yes, and the legitimizing political legitimization of this administrative work. So it's not that because the people elected certain leaders, is that they are untouchable and they are not accountable for what they have done, how they allocate their financial resources, how they think of their management without thinking of the consequences of their acts. It generated a reaction out of measures, and it does not bring opportunity for debates. It's the opposite. It stops the debate, and it promotes many drawbacks in the structure of the Brazilian state, with insensitive points of the Brazilian society, preventing a pluralist point of view, and threatening constantly the Constitution of 1988 with non-republican actions, and projected and built without transparency and without public debate. I'm talking about what brought the origin of the LINDP, and because the prosecutor's office has received this type of retaliation. I know it's not part of our discussion here, but when we look for fiscal budget responsibility and the decision institutions, the Brazilian parliament must respect the legislative process, the need for a transparent public debate. If they are elected people, they exist in the affirmation of the constitutional competency of each power in the limits of the Constitution, so that we will not have this culture of drawbacks and retaliation. So I think this debate we had today enabled us to demonstrate that it is possible to reflect, to have a constructive reflection, even when the topic that is debated was thought in a way of making it smaller. And this is what we need: public debate, transparency, and clarity on the premises of what we are discussing. So I thank you for the opportunity. I'm sorry for my comment, but I think it was really necessary to register this in my concern of the public careers that we have in the public sphere, in the public debate. I'm not looking for a concrete result in the consequence, but the consequences and the results, the premises, should be more frequently debated. Thank you so much. Well, excellent. I'd like to thank you all for your presence in this panel. Regarding this topic, I would just say that the Budget Week has as an anchor the topic of budget governance. This panel attempted in a very effective way to talk about the consequentialism. So if there is a debate for that, for the consequentialism to be implemented, is in the process of creation of budget law. The consequentialism, not the rhetoric consequentialism, but the one that is based in data, in evidence. And the legislators that have the power to decide where the scarce financial resources that we see today, for this person to decide in a simple way and respecting the values that they're looking for, but meeting concretely the values that they need to meet, such as health and education. And for that, they need evidence to have a better decision on allocating the budget. I have several questions that were asked by our audience on YouTube. And fortunately, because the debate was quite rich, but unfortunately, on the other hand, I could not ask the questions. So I'd like to tell our audience on YouTube that your questions will be forwarded to the specialized sector here, the SEMAG, and they will use your insights in the continuation of the works of monitoring. I'd like to invite you all to participate of next panel, panel 6, that will start at 2 p.m. The title is Indicators of Budget Governance in Public Administration. We'll have Justice Augusto Nardes in this panel. So I would like to thank the virtual group, and I think the debate is finished now.